Good evening, students. Welcome, everyone. My name is Rohit, and today we will start the pardoning power of the president, and then after we will start the new topic, and that is the governor. Okay, so first let us start the pardoning power of the president. Okay. Okay. So first important thing that the pardoning power of the president. The pardoning power of the president is under Article 72. And here we can write that the pardoning power of the governor is under Article 161. So we will not study the pardoning power of the governor separately. We will just write the article and the difference between the pardoning power of the president and the governor. So the pardoning power of the governor is under Article 161. So here we can write pardoning power of the governor. Okay. Now, under pardoning power, we have to first study that under which circumstances the president can exercise the pardoning power. See, the constitution has conferred pardoning power upon the president as well as on the governor. So both have pardoning power. The president has pardoning power under Article 72 and the governor has pardoning power under Article 161. Now the question arises, who will exercise the pardoning power when? Under which circumstances? So first we will discuss that the pardoning power of the president is exercised under which circumstances or in which cases. Okay, so in which cases the president can exercise pardoning power? The first case is where the punishment or sentence is by court martial. Okay, so suppose military it is all about military code. Okay, military code giving punishment to their soldier. So this is called as court martial. So if the punishment is given by court martial, in these cases the president can exercise pardoning power. Remember, where the punishment is given by court martial, the governor cannot exercise his pardoning power because president is the supreme commander of defense forces. So the governor cannot exercise pardoning power in those cases where the sentence is given by court martial. So this is the first thing that you have to remember, and this can also be seen as a difference between the pardoning power of president and governor. Only president can exercise in the court martial cases, governor cannot. Now second, where the punishment or sentence is for an offense against union law. Okay, so see, the union government has the authority to make law, whereas the state government has the authority to make law on a state subject. Okay, so suppose a law is made by the parliament. Okay, and if you have violated that law, then the president will exercise the pardoning power. In those cases where you have committed a crime and that crime was for violating a law made by the parliament. Okay, so here the governor cannot exercise pardoning power. See, for governor you have to remember, the governor can exercise pardoning power where the sentence is for an offense against state law. If the offense is for a union law, then the president will exercise. If the offense is against a state law, then governor will exercise the pardoning power. So this is the second point. And the third is that the sentence is death sentence. Sentence is death sentence. Now, suppose you have been given death sentence for violating a law made by the state. So ideally the governor has the right to exercise pardoning power, but where the sentence is death sentence, and now it is irrelevant whether that death sentence is given to you because you have violated a union law or state law. Now this is irrelevant. Only the president can pardon a death sentence. See, it doesn't mean that the governor has no authority over the pardoning power, over the death sentence. The governor can commute death sentence into life imprisonment. Okay, governor can reprieve the death sentence. I mean, it can stay the execution of death sentence for a particular time period. But the death sentence can be pardoned only by the president. The governor cannot pardon a death sentence. Okay, so even if the punishment is for offense against state law, still only the president can pardon the death sentence. Governor cannot pardon a death sentence, but that doesn't mean that governor cannot do anything on death sentence. The governor can convert death sentence into life imprisonment, but the governor cannot pardon a death sentence. So we can write here under a note, and we can mention that governor cannot pardon a death sentence. Governor cannot pardon a death sentence. Okay, so when the governor will exercise his pardoning power, the governor will exercise the pardoning power where the punishment is for an offense against state law. For union law, president; for state law, it is governor. And the governor cannot exercise pardoning power in those cases where the punishment is by court martial, and in those cases where the sentence is death sentence. Though he can commute a death sentence, but he cannot pardon a death sentence. Okay, see, pardon means to completely free the person, okay, as if he has never committed a crime. So here we are talking about the word pardon, not pardoning power in general. See, pardoning power is different and pardon is different. We are saying the governor cannot pardon a death sentence. We are not saying the governor cannot exercise pardoning power on death sentence. The governor can exercise pardoning power on death sentence, but he cannot exercise pardon or death sentence, because there are 5 types of pardoning powers. One of the type is pardon. Okay, so he cannot pardon, but he can use the other options. Okay, so now we have seen that in which circumstances the president can exercise pardoning power and what are the limitation upon the pardoning power of the governor. And now we can start with the types of pardoning power. So there are total 5 types of pardoning power. Now the first pardoning power is the pardon. Okay. In the previous slide, I was trying to explain you the difference between the pardoning power and pardon. Okay. So pardoning power is of 5 types. The first is pardon. Now what is the meaning of pardon? The pardon means to completely absolve the convict. Okay. First let us write to absolve the convict. So when we write absolve the convict, the only thing that might confuse you is the word absolve. For those who don't know what is absolve, absolve means to completely free that person. So when I say pardon means to absolve the convict, it means suppose he has been given death sentence by the court. Then remember, if the president decides to pardon the convict, then he will be free. Okay, all the punishment, all the disqualifications will be removed from him. Okay, so pardon means to absolve the convict. It means now he is completely free, as if he has never committed any crime. All the disqualifications are also removed. Now this is pardon. Now second, after pardon, the second power with the president is commutation. Now what is commutation? Commutation means to change the character of the sentence. To change the character, of the sentence. Now, in order to understand what is meant by changing the character of the sentence, we can consider the example of death penalty. Suppose a person has been given death sentence by the court. If the president exercises pardon, the first power, then he will be absolved completely. But if the president decides to use commutation, so here commutation means in place of one punishment, you will be given another punishment, and the another punishment should be lighter in form. So it means a person has been given death sentence and president exercised commutation. Now his death sentence can be converted into life imprisonment. So it means in place of one sentence, we have given you, in place of one punishment, we have given you another type of punishment. Okay. So commutation means when we convert the character of the sentence. So initially the sentence was death sentence. Now we change the character of the sentence and now the sentence is life imprisonment. So it means changing the character of the sentence. This is called as commutation. Okay. Now, after commutation, the third is remission. Okay. Now, what is remission? In remission, the character of the sentence is not changed. We only reduce the amount of sentence without changing its character. For example, suppose a person has been given 10 years of imprisonment. What president did? President converted 10 years into 5 years of imprisonment. So still the sentence, still the punishment is same. You have to be there in the jail. But right now the time period has been reduced. Initially you have to serve 10 years, but now you will serve only 5 years in the jail. So it means without changing the character of the sentence, we have reduced the amount of sentence. So remission means to reduce the amount of sentence without changing the character of the sentence. For example, 2 years of imprisonment has been reduced to 1 year of imprisonment. So the punishment is same, you have to be in jail, but the time period has reduced without changing the character of the sentence. So remission means to reduce the amount of sentence, without changing its character. To reduce the amount of sentence without changing its character. For example, 2 years of imprisonment has been converted into 1 year of imprisonment. The time period has been reduced. So this was the third, remission. Now the fourth is respite. Respite means under special circumstances, the president decided to either postpone the sentence or award a lesser sentence to you owing to special factors. Now here special factors could be a pregnant woman or a disabled person. So because of these special factors, the president has decided to either postpone the sentence or to award a lesser sentence. Okay, so respite means to award a lesser sentence, due to some special factors, we can also say under respite the sentence can be postponed. Okay, and what are those special factors? So in these special factors you can write a pregnant women offender or a physically disabled person. These could be special factors for respite. Okay, now this was the respite. Now the fifth and the last pardoning power of the president is reprieve. Okay, so reprieve means stay on the execution of sentence, for a temporary period. So usually reprieve is exercised only in the cases or especially in cases of death sentence. So this particular power is exercised especially in case of death sentence. Okay, now the purpose of exercising reprieve is to ensure that the convict has sufficient time to send his case to the president and seek the pardoning power of the president. Okay, so in order to seek pardon from the president, we can stay the execution of sentence obviously for a temporary period. So meanwhile the president will give the answer to the convict. And remember one thing, under the constitution there is no time limit for the president. I mean, nowhere in the constitution it is mentioned that when the president should give his answer. So suppose a person a person has been sentenced, a person has been given death sentence and now he has sent his case to the president. So there is no time period for the president to give his judgment or exercise his pardoning power. So a president can delay the execution of the sentence and the president can give answer in 1 year, 2 year, 5 year, 10 years. Now it all depends upon the president. So there is no time period for the president as to when the president should exercise the pardoning power. But according to Supreme Court, there should be a particular time limit, because if a person who is a death convict, okay, so in this case, you cannot keep on delaying the execution, because that person will always expect that the next day the president is going to give the answer, and that might be the last day for him. So that person will die each and every day. So we cannot keep on delaying the execution of sentence for indefinite period, and that person will always be under a threat or under an apprehension that what will happen if the president say no. Okay, so keeping this in mind, the Supreme Court has said that ideally the president should exercise pardoning power as soon as possible when it comes to the death penalty cases. Okay, so this was the reprieve, and with this we are done with the pardoning power of the president. Okay, so in the pardoning power of the president, we have to remember two things. The first is under which circumstances the president can exercise pardoning power. We have discussed there are total 3 circumstances, and we have also compared the difference with the governor, that what are the differences, where the governor cannot exercise the pardoning power and where the governor can exercise the pardoning power. We have also seen a limitation upon the power of governor, and that is the governor cannot pardon death sentence, but he can exercise other pardoning power on the death sentence. And one more thing, the governor cannot exercise pardoning power on those sentences which were given by the court martial. He can exercise pardoning power in those cases where the punishment is for an offense against state law. So this was the pardoning power of the governor and the president, and then there were total 5 pardoning power of the president. Okay, with this we are done with the pardoning power of the president. But remember, when it comes to civil service examination, so there are many cases in the pardoning power of the president. For example, Maru Ram case, then Shatrughan Chauhan case, then Ipuru Sudhakar case. So there are many cases, and in those cases Supreme Court has tried to lay down some kind of guidelines. Okay, so in fact, in one of the cases Supreme Court held that the pardoning power is so vast and there are myriad of situations that we cannot issue guidelines, okay, for the exercise of pardoning power. So in all these cases are discussed when we are studying for civil service examination, but as far as your examination is concerned, we do not have to study about all these cases. But remember, the decision of the president to pardon a person is subject to judicial review on the ground of mala fide intention. It means, suppose the president has pardoned someone, so the decision of the president to pardon a particular person can be questioned in the court, okay, on the ground that it was under the mala fide intention. So it means the president's decision under pardoning power can be subjected to judicial review. Okay, so even the president's pardoning power is not immune from judicial review, because judicial review is a part of basic structure of the constitution. And if anything is a part of basic structure of the constitution, then nothing on this earth can violate it. Okay, so pardoning power is subject to judicial review. Okay, and one more thing, never assume that president is trying to pardon someone based on his personal judgment. No, president is no one to pardon anyone based on his personal satisfaction or judgment. It is always about the Home Ministry. It is the Home Ministry which is going to recommend to the president that whether you pardon that person or whether you exercise commutation, it all depends upon the Home Ministry. So basically the case is sent to the Home Ministry, and it is through Home Ministry that the powers are exercised by the president. So basically, upon the advice of a Home Ministry, the president exercises the pardoning power. There is no personal judgment of president involved. And the same is with the governor. In case of governor, the governor's personal satisfaction or judgment is not at all relevant. Okay, it is all about the government, Home Ministry. Okay, so with this, we are done with the 3 powers of the president. The 3 powers of the president were first we discussed veto power of the president, the second was the ordinance making power of the president, and the last was the pardoning power of the president. Other powers of the president will be discussed in separate chapter. For example, we discussed emergency powers of the president under a separate chapter, emergency provision. Similarly, we will discuss the financial power of the president under the category money bill and in the finance commission chapter. Similarly, we will discuss the executive power of the president when we will be studying the appointment of the prime minister, appointment of CAG, election commission members, UPSC members. So all these things will be discussed when we will be discussing those chapters. Okay, so the powers of the president are discussed in separate chapters. Now, the next topic after the president and vice president is the governor. See, the functions performed by the president at the center and the functions performed by the governor at the state level are same. Okay, there is no difference. The only difference is that the president is the head of the state of the whole country, whereas the governor is the head of the state. It means of that particular state. So both governor and president are the head of the state. So the topic governor is under which part of the constitution? The topic governor is under part 6 of the constitution. And how many articles are there? There are total article 153 to 167. So these articles are dealing with governor, but remember, these articles are not only concerned with the governor. I mean, the executive organ of the state government is under these articles. So article 153 to 167 is related with the state executive. Now remember, here state executive means executive organ of the state government. So who all comes under the state executive? The first is governor, the second is chief minister, the third is state council of ministers, the third is state council of ministers, and the fourth is the highest law officer of the state, and the highest law officer of the state is the advocate general of the state. Advocate general of the state. So remember, Attorney General of India is the highest law officer of the country. The highest law officer of India is Attorney General. Similarly, the highest law officer of the state is Advocate General, and both are part of Union Executive and State Executive. It means Attorney General is the part of Union Executive and Advocate General is the part of State Executive. Okay, but they are considered as part of Executive. Now, first we will start with the basics of governor. So we all know first from where we have borrowed the office of governor. So the office of governor has been borrowed from Government of India Act 1935. Government of India Act 1935. Okay, and we all know governor is the nominal executive. See, president is also a nominal executive and governor is also a nominal executive. Governor is also head of the state. Governor is the head of the state. One more thing, it is also said that governor is the agent of the central government. Okay, in many books it has been written that the governor is the agent of the central government. Okay, governor acts as the eyes, ears of the central government. It is through the office of the governor that the center tries to bargain with the state government. It is through the office of the governor that center tries to control the state government, and we all have seen that there are chances that upon the recommendation of the governor, the president's rule can be imposed on a particular state. Okay, this happened especially in 1988 when the president's rule was imposed in Karnataka, Nagaland. In these states, upon the recommendation of the governor, the president's rule was imposed. So the office of governor has become controversial, especially because of the power given to the governor. Sorry, not the power given to the governor, especially because of Article 356. Because it is under Article 356 where the president, where the governor on behalf of the president carries on the administration of the state. Okay, so the office of the governor has become controversial, and many times you might find that there is a demand that the office of governor should be abolished owing to the controversies associated with the office. Okay, so but the fact is that at the central level and at the state level we have parliamentary government, and in parliamentary government it is a feature to have nominal and real executive. So to have a nominal executive is a part of parliamentary government. I mean, it is a feature of parliamentary government. So that is why because of the parliamentary form of government, it is compulsory to have a nominal executive in the state, and that nominal executive is the governor. Okay, but all the offices in this country should exercise or should observe constitutional morality. It means they should adhere to the principles of the constitution. So whenever any, okay, प्रियांशु मैथ लेक्चर यू आर सेइंग दैट सर हिंदी में सी ऐसा नहीं है कि मुझे हिंदी नहीं आती, मैं तो खुद बायलिंगुअल टीचर हूँ, बट द फैक्ट इज दैट this particular channel is dedicated to those students who are not comfortable with English, who are not comfortable with Hindi. सो देयर आर मेनी स्टूडेंट्स फ्रॉम साउथ इंडिया, बहुत सारे बच्चे होते हैं साउथ इंडिया से, बहुत सारे बच्चे होते हैं नॉर्थ ईस्ट से, तो यार उनके लिए ना पॉसिबल नहीं हो पाता है ना हिंदी को समझ पाना। तो आप जिस पर्टिकुलर चैनल पर आए हैं ये सब देखने, वहाँ पर लिमिटेशन ये है कि हमें इंग्लिश में बोलना पड़ता है, क्योंकि हमारी जो ऑडियंस है वो ऑडियंस है बेसिकली वो जिनको इंग्लिश जो हिंदी में कंफर्टेबल नहीं होते हैं। तो इसीलिए मैं इसमें माफ़ी चाहता हूँ कि मैं यहाँ पर एक्चुअल में हिंदी में समझा नहीं पाऊंगा, क्योंकि इस क्लास को लाइव कम देखते हैं, बाकी के लोग ज़्यादा देखते हैं ऑफलाइन में, मतलब ऑफलाइन द सेंस मतलब रिकॉर्डेड बाद में देखते हैं, तो इसलिए या हिंदी नहीं बोल पाएंगे इसलिए, ठीक है। लेकिन करियरविल के बाकी के जो चैनल हैं वहाँ पर आपको हिंदी यूज़ होती है वहाँ पर, तो आप वहाँ पर जाकर पढ़ सकते हैं, ठीक है। लेकिन इस क्लास की लिमिटेशन है, यहाँ पर इंग्लिश वाला पार्ट चलता है, ठीक है। ओके, लेकिन अगर आपको थोड़ी बहुत इंग्लिश समझ में आ रही है तो आप वेलकम है, आप पढ़ सकते हैं, ठीक है। और ऐसा नहीं है मैं कोई बहुत तगड़ी इंग्लिश नहीं बोल रहा हूँ, मैं तो बहुत ही सिंपल इंग्लिश बोल रहा हूँ, तगड़ी इंग्लिश तो मुझे खुद नहीं आती है, ठीक है। ओके, सो I hope we are done with the basics. I mean, from where we have borrowed the office of governor. Governor is the nominal executive like the president, and the governor is the head of the state. And one more thing, we have seen that the office of governor has become controversial, especially because of several provisions of the constitution. Okay, the governor can reserve a bill for the consideration of the president. This can also be seen as a controversial provision. Okay, so there are many controversial provisions related to governor. Okay, so now the next thing. Now we can start with first Article 153. So first we will start with Article 153. And now what is Article 153? According to Article 153, there shall be a governor. There shall be a governor for each state. So what is Article 153? According to Article 153, there shall be a governor for each state. So there are total 28 states in our country. So in all those 28 states, there should be a governor. Okay. So if there are 28 states, then there should be 28 governor. So this particular article says that there should be a governor for each state. But there is one catch. And the fact is, by the 7th Amendment Act 1956, it has been mentioned under the same article that same person can be appointed as governor of two or more states. Governor of two or more states. So it is possible for the government to appoint the same person as the governor of two or more states. This particular provision has been added by the 7th Amendment Act. And one more thing you have to remember, and that is by the same Amendment Act, it has been said that a common high court can be established for two or more states. So at present we have three common high court. The first is Punjab and Haryana High Court, and the second is the Bombay High Court for Maharashtra and Goa, and the third is the Guwahati High Court covering 4 northeastern states. So by the 7th Amendment Act, first point that you have to remember is that a same person can be appointed as governor of two or more states. And similarly, by the same amendment, it has been said that a common high court can be established. So a common governor and same common high court. So common high court can be established for two or more states. And at present, we have total three common high court. Okay. So but we will discuss this particular point in the separate chapter, that is High Court. But we can remember, because we are discussing the 7th Amendment Act. So common high court can be established. Common high court can be established for two or more states. For two or more states. Okay. So I think this is clear that what is Article 153. And remember, if yes, Priyanshu. In fact, for the last 9 years, I have been teaching constantly in Hindi. I mean, when I say Hindi, it means bilingual. We usually teach in Hindi, and I mean, in my class, both English medium and Hindi medium students were present. Okay, so it's not an issue for me to teach in Hindi. In fact, I have teach all those students who do not understand English, and I have teach those students who do not understand English, and I teach those students who understand both English and Hindi. So it's normal for me to change the language. Okay, I can explain this entire topic in Hindi. Okay, but the fact is that this particular channel is Careerwill GS English medium, so there is a limitation. Okay. Okay, so what we were saying, yes, I hope Article 153 is clear. So in Article 153, what you have to remember, the first is the heading. there shall be a governor for each state. But it is possible for the government to appoint the same person as the governor of 2 or more states. This particular provision was added by the 7th Amendment Act 1956, and the same amendment said that the common high court can be established for 2 or more states. So with this, Article 153 is over, and now we can start with the one more thing I forgot to mention. Suppose a person has been appointed as the governor of 2 states. Now you don't think that the salary will be doubled. No. If a person is governor of 3 states, so do not consider that he will receive the salary of 3 governors. Okay, see, the salary of governor is 3.5 lakh per month. So if a person is the governor of 3 states, so you cannot assume that he will get 10 lakh 50,000 rupees because he is the governor of 3 states, so he will receive the salary of each and every state governor. Okay, no, that is not possible. Whenever the person is appointed as a governor of 2 states, so the salary is distributed between the 2 states, and the in the ratio it will be distributed, that will be decided by the president. So the president determines in which ratio the salary will be given by which state. Okay, so there is no concept of double or tripling the salary of the governor. Okay, he will receive the same amount. The other state can be considered as the additional charge of the governor. Okay, so Article 153, and now Article 154. Now Article 154 says that the executive power of the union, the executive power of the state, the executive powers of the state shall be vested in the governor. Okay, now do you remember in Article 53 we studied the executive power of the union shall be vested in the president, and under Article 154 now we are studying the executive power of the state shall be vested in the governor. So the point is simple, the executive power of the union is vested in the president and the executive power of the state is vested in the governor. Okay, now after Article 154, now Article 157. Now Article 157 is the qualification of governor. So we can simply write the heading qualification. So what are the qualifications for the governor? Okay, so there are only 2 qualifications. The first is he should be a citizen of India, and the second is he should have completed 35 years of age. So there are only 2 qualifications. The first is simple, should be a citizen of India, and the second is that he should have completed 35 years of age. So it means that for the office of president, for the office of governor, and for the office of vice president, the age is same, 35 years of age. See, for prime minister or ministers, the minimum age is 25 years. But for the president, vice president, and governor, the minimum age is 35 years. And remember, there is no maximum age for the governor. And see, same is for the president and vice president. There is only minimum age of 35 years for president, vice president, governor. But there is no maximum age for the president, vice president, or governor. Okay. So this is the qualification for the governor. And remember, there is no educational qualification prescribed for the office of governor. In fact, be it the office of president, vice president, prime minister, there is no provision for educational qualification. And I think that it is high time for the lawmakers to consider this option, that the educational qualification should also be seen as a proper qualification under the qualification heading of all the functionaries. So, but the fact is that these laws are going to be made by those who are basically uneducated. So you cannot expect them to add this particular qualification in the constitution, that the particular person should be educated or he should have attained at least this or that. No. How come they are going to add when they themselves are uneducated? Okay, they do not have the focus on the education, so that is why they will never add such kind of qualification. Okay. No, I just teach on this channel. Okay, so this is also a limitation. Okay, so I hope qualification is clear. It is under Article 157. And after qualification, now we can start the appointment of governor. Okay, so remember, in appointment, you have to just remember that the president is, the governor is appointed by the president. There is no election for the governor. The governor is appointed by the president. See, president is elected by an electoral college, but the governor is not elected. the governor is appointed. During the framing of the constitution, there was a proposal that the governor should be elected, and in the draft constitution, there was a provision that the governor should be elected in the same manner the governor is elected in the United States of America. So earlier we thought that the governor should be elected in each and every state, but this particular provision was met with resistance, and particularly because the governor is the nominal executive, the real powers are vested in the chief minister and council of ministers. So there is no point of conducting election of the governor. Why the governor should be elected? Because under the constitutional scheme, he only enjoys the nominal authority. So he exercises all the power on the aid and advice of council of ministers. So what will be the point of electing the governor when he is going to function on the aid and advice of the council of ministers? So that particular provision of election of the president was dropped, and the Canadian provision, see, according to the Canadian constitution, the governor of each provinces is appointed by the governor general. So the governor of each province is appointed by the governor general. The same concept has been adopted in our country. So the governor of each state is appointed by the president. See, we do not have governor general. In place of governor general, we have president of India. So the president of India appointing the governor is a provision taken from the constitution of Canada. So appointment, in appointment, you have to understand that the governor is appointed by the president. Governor is appointed by the president. Okay. And the appointment, I guess appointment is under Article 155. Okay. So the qualification 157, appointment 155. The governor is appointed by the president, and the appointment has been borrowed from Canadian Constitution. Appointment is borrowed from Canadian Constitution. Okay. Appointment has been borrowed from Canadian Constitution. So I think the appointment part is clear, and why it is not at all relevant to hold election for the office of governor, because ultimately if the governor is also elected, then there will be a dispute in the state, and that dispute will be about the center of power. There will be two center of power if both the chief minister and governor enjoys the support of the public. If governor is elected, then he also enjoys the support of public. If the CM is also, and obviously CM is elected. So no, in technical sense, CM is not elected, CM is appointed, but the fact is that CM enjoys the support of the people. But if the governor also enjoys the support of the people, then we will have two center of powers in a state, and that will lead to a dispute during the time of taking decision. Because the governor will say, no, I will not pass this because I also enjoy the support of the public. So there will be a dispute between the governor and CM if both are elected, okay? Because they both will have the valid point that we enjoy the support of the masses. Then how come one could be superior than the other? So Article 154 executive power, 157 qualification, 150 appointment. Yes, I forgot to mention the oath. No, obviously after appointment the oath should come. Now the oath. So the oath of the governor is that the Chief Justice of High Court shall administer oath to the governor. Okay. So oath is administered by the Chief Justice of High Court. By the Chief Justice of High Court. Okay, now there might be a confusion among the students, and the confusion is the president appoints the governor, but remember, it is not always that the one who appoints the governor is also going to administer the oath. See, the governor is appointed by the president, but when it comes to oath, president do not administer the oath. The oath is administered by the Chief Justice of High Court. See, the pattern is simple. Chief Justice of Supreme Court administers oath to the President. Likewise, the Chief Justice of High Court administers oath to the Governor. Okay. So for president, it is Chief Justice of Supreme Court, and for governor, it is Chief Justice of High Court. Okay. So the oath is administered by the Chief Justice of High Court. Okay. So this is the oath of the governor. And after oath, I think the oath of the governor is under Article 159. I might be confused with the article. I think it is 159. Okay. Now after Article 159, it is Article 156, and Article 156 deals with the term of office of governor. Term of office of governor. Now remember, in this, the first point is the governor shall hold office during the pleasure of the president. The first point is simple. Governor shall hold office. The governor shall hold office during the pleasure of the president. During the pleasure of the president. See, remember, the tenure of the governor is 5 years. Okay, it is the fact. The tenure of the governor is 5 years. But you have to remember that the governor shall hold office during the pleasure of the president. It basically means that there is no guarantee of tenure of governor. Yes, the governor holds office for a period of 5 years, but the governor can be removed from the office at any time because there is no charge against the governor. See, for removing the president, there is a charge called violation of the constitution. But for removing the governor, there is no charge mentioned in the constitution. Similarly, there is a procedure for the removal of the president called impeachment. So there is a special procedure under the constitution for removing the president, but there is no special procedure for removing the governor. And for governor, the answer is simple. The governor holds office during the pleasure of the president. It means the governor can be removed from the office at any time because there is no charge and no special procedure. So under normal circumstances, governor holds office for a period of 5 years. Okay, he holds office for a period of 5 years, but he can be removed earlier. How? Simply by the president. The president can remove the governor at any time. In between these 5 years, he can remove the governor at any time. Okay, so this thing you have to remember, that the governor hold office during the pleasure of the president. The second thing, yes, the resignation of the governor is given to the president. Resignation is given to the president. Is given to the president. And third and the last point is governor holds office for 5 years. So the time period of the office of governor, the term of office of governor is fixed, 5 years, but he can be removed at any time. So there is no guarantee of tenure of governor. And one more thing, there is one circumstance, in a particular case, the governor can hold office beyond 5 years. Okay, so under which circumstance the governor can hold office beyond the period of 5 years, and it is when the successor of the governor has not assumed the function of the office of governor. See, the office of governor can never remain vacant. There should always be someone acting as the governor. So if there is no governor, then the Chief Justice of High Court will act as the governor. But the fact is that suppose the 5 years of governor is over. Okay, the 5 years are over. Now, if there is no successor, then the same governor will continue to hold office beyond the period of 5 years. So under which circumstance the governor can continue beyond 5 years? Only when his successor has not assumed the function of his office. Okay, until the successor assumes the function, the governor will remain even beyond the period of 5 years. And the same is applicable for the president. If the office of president is for 5 years. Now suppose the 5 years are over and there is no successor, then the president of India will also hold office for a period of more than 5 years until his successor assumes the function of the office. In this case, vice president will not get the opportunity to become the president. Vice president gets the opportunity to become the president only when that during the period of 5 years, if the office of president is vacant or the president is absent or unable to continue the office, then the vice president can become the president. But if the president is there and the 5 years are over, then the same president is going to continue to hold the office until his successor assumes the function of his office. So the same is applicable for both president and governor. Both president and governor can continue beyond a period of 5 years. Okay, and there is the same logic. So I think we are done with the tenure of the governor, the term of office of the governor, and whom he should give resignation. So this is Article 156. And one more thing. See, while studying the president, I said that the president should not hold office of profit. The same is applicable for the governor. The governor should not hold office of profit, and the governor should not be a member of parliament or member of either house of state legislature. Okay, and if any person who is a member of parliament or member of state legislature is appointed as the governor, then it is assumed that he has vacated his office on the date on which he assumed the function of the governor. Okay, so it is automatically considered that you have vacated the office of member of parliament or member of state legislature once you are appointed as the governor. Okay, so this is with the governor, and the same is with the president. President can also be neither a member of parliament nor member of state legislature, and the same logic applies for the president. Okay, so this was the governor. So in governor we discussed all the basics of governor, and now we can start with the two important articles related to governor, and these are Article 200 and Article 201. Okay, basically these are the veto power of the governor. See, the veto power of the president was discussed under Article 111. So similarly, the veto power of the governor will be discussed under Article 200. But there are two articles that we have to remember, Article 200 and Article 201. Okay, so let us start Article 200. Okay. So under Article 200, if a bill which has been passed by Legislative Assembly and Legislative Council, then that bill will be sent to the governor for the signature. So under Article 200, it is mentioned that how many options governor have. Okay. So under Article 200, there are 4 options available with governor. So what are the 4 options under Article 200? The first option is to give his assent to the bill. It means to say yes, to give his assent to the bill. So if the president gives his assent to the bill, then the bill will become an act. Okay. And the second option is to say no, that is to withhold his assent to the bill. To withhold his assent to the bill. In this case, the bill ends. Third, to return the bill. To return the bill for reconsideration. To return the bill for reconsideration. But remember, the governor cannot return a money bill. I mean, when it comes to the president cannot return a money bill. Similarly, the governor cannot return a money bill, and for the governor, the same logic applies. If the governor has returned a bill once, then in the second instance, he must give his assent to the bill. The same is with the president. The president can return a bill only once, and similarly, the governor can also return a bill only once. So it means suspensive veto is same in both the case. For president, the suspensive veto means the president can return a bill only once, and in the second instance, he must give his assent to the bill. Same is the case with the governor. The governor can return a bill only once, and in the second instance, he must give his assent to the bill. So the governor can return a bill only once, but he cannot return a money bill. Okay, now the fourth point. The fourth option was not available with the president, but this option is available with the governor. And the fourth option is to reserve the bill for the consideration of the president. To reserve the bill. To reserve the bill for the consideration of the president. For the consideration of the president. Now remember, president cannot reserve a bill for anyone. No, president has no, there is no option available with the president, because there is no one above the president for whom he can reserve the bill. But for above governor, there is president. So the governor can reserve the bill for the president, but the president cannot reserve the bill for any other person or authority. So the fourth option is to reserve the bill for consideration of the president. And now remember, if the governor exercises the fourth option, then what will happen? So if the governor decides to reserve the bill for the consideration of the president, then the bill will be sent to the president. And if this happens, then the president will have option on that particular bill. So under Article 201, it is mentioned that how many options are there with the president. So there are total 3 options available. And those 3 options with the president are, the first is to give his assent to the bill, and if this happens, then it will become the act. The second is to withhold his assent to the bill. It means the bill will end. And the third option is to return the bill for reconsideration. And now remember, if the president returns a state bill, then 2 points you should remember. The first, if the president has returned a state bill, then the state legislature has 6 months for reconsideration. And after reconsideration, the same bill with or without amendment should be sent to the president and not to the governor, because once the bill is reserved by the governor for the president, then there is no turning back. The function of governor is over on that particular bill. Now all the decisions shall be taken by the president and not by the governor. So once the governor has reserved a bill for the president, the role of governor on that bill is over. So it means if the president has returned a state bill, then within 6 months, yes, there is a time period, within 6 months, the bill should be returned to the president with or without amendment. And the second thing that you have to remember, that it is not at all compulsory for the president to give his assent in the second instance. See, when the president returns a bill passed by Lok Sabha and Rajya Sabha, then there is no time period. Okay. And the president is bound to give his assent in the second instance. When the governor returned a bill passed by the state legislature, then there was no time period for the state legislature to pass the bill. And in the second instance, the governor was bound to give his assent to the bill. So it means both president and governor are bound to give their assent to the bill if it is passed by the parliament or state legislature. Okay. But what happens when a state bill is returned by the president? See, let me clarify this if you are still confused, because I cannot see your comments. I mean, no one is actually giving any comment. So the first is simple. If the president has returned a union bill, then there is no time period, and in the second instance, the president must give his assent to the bill. If the governor has returned a state bill, then there is no time period, and the governor has to give his assent in the second instance. But if the president has returned a state bill, then there will be a time period of 6 months. And within these 6 months, the state legislature should pass the bill with or without amendments, and the same bill should be given to the president. And now it is not at all necessary for the president to give his assent in the second instance. So it means the president in the second instance can withhold his assent. Okay, but there is no mention in the constitution that whether the president can return the state bill in the second instance. The only thing that is mentioned is that that it is not obligatory for the president to give his assent in the second instance. He may withhold his assent, but there is no mention of the president returning the bill in the second instance. Okay, so I hope this thing is clear, that when the president decides to return a bill or return a state bill, there are two provisions. The first is there is a time period of 6 months, and the second is even in the second instance, the president may refuse to give his assent. Okay, but this happens only when the president has returned a state bill. If it was the case of the union bill, then there was no such provision of the president, that for the president to return the bill in the second instance or to withhold his assent in the second instance. He must give his assent to the bill. Wait a minute. Sorry. Okay, so I think with this the chapter governor is over, because see, when it comes to the ordinance making power of the governor, we just have to remember the article, that is article 2 and 13, because the maximum life of an ordinance is 6 months and 6 weeks, whether it is for the president or for the governor. In both the case, the ordinance life is 6 months and 6 weeks, and both the conditions are also same in the case of governor. So we do not have to study the ordinance power of the governor. The pardoning power of the governor we discussed, and that two differences. What are the differences between the president's pardoning power and the governor's pardoning power. So the only thing that we have to discuss in the chapter governor was the veto power of the governor, because in the veto power of the governor, we will find that there is an extra option available with the governor, which was not available with the president. Okay, so with this, the chapter governor is over. I mean, we have completed all the relevant points. Okay, all the relevant points are over, and now with this, the class is also over. And tomorrow we will study the chapter Prime Minister and Council of Ministers. Okay, so the next topic will be the Prime Minister and Council of Ministers. Okay, okay, so I think we have completed all the I'm just trying to figure out that we have discussed all the important things. Yes. Okay, so we have covered all the relevant and important points for your examination. Okay, then we will meet tomorrow, same timing, 8:30 to 9:30, and you all should subscribe. Okay, if you want to attend more such lectures. Okay, okay. So thank you, everyone.